I am absolutely delighted to introduce my partner, Anthony Gair. And without going through Tony's bio, let me just say this to you. Tony is absolutely responsible for converting me from a defense attorney to a claims attorney. And I personally am forever grateful to Tony for doing that. But more importantly, for your purposes, he is truly, within the state of New York, the go-to guy on these labor law cases. When it comes to any issues of the law, Tony is the guy. And any day, any week, in our office, lawyers are calling him throughout the state, asking him about what the recent changes are in the labor law, what are the new cases, how do they apply to a particular fact pattern that attorney has. And so that is the highest praise I can give him, which is that he spends so much of his time dealing with other lawyers who constantly and continually call on him for his professionalism. What he's going to talk to you about today is the current state of the labor law, which of course is changing on a daily, if not weekly basis. So I give you my partner, Tony.
Thank you, Howard. Good morning. Can everybody hear me back there? Okay. So the current state of the labor law, I think it's do you have a case? I'm going to concentrate on Section 240 cases for two reasons. That's where all the action is certainly right now. And the 241-6 and the 200 cases, we all pretty much know 241-6, you have to have a specific enabling regulation for the industrial code. There's questions whether it applies, whether it doesn't. In 200, we know that it's either a dangerous condition or a methods in operation case. They're all set forth in the course book. I just want to, before I get started, I went over the roster and I recognize a lot of names, but how many of you practice in the labor law or construction accident area on a regular basis? All right, quite a few. And how many for defendants, firms, carriers, that type of thing? And plaintiffs? Okay, so we got a lot of defendants here, which is fine. Most of the lawyers, no, most of my friends in this business are defendants, lawyers. That's who I'm with all the time. I'm not going to be talking about a lot of individual cases. It would bore you to death. It would put you back to sleep, and you can read it as well as I can read it. What we have to focus on in order to understand whether we have a case as plaintiffs or whether you as defendants can defeat a case is the concepts. So, as we all know, and a great many of you, I just see, practice in the area of construction law, this area of the law changes in the state of New York more than any other. It's like a pendulum going back and forth. You can go back to the late 70s through the early 90s. It was really favorable to the plaintiffs. And then starting in the late 90s, certainly when we had Blake in 2003 and Cahill in 2004, started swinging much more to the defendants. And recently, it's really swung back again towards the plaintiffs. And certainly there's two recent cases and we'll discuss them. So we all know what was current last year at the time we gave this seminar might not be so current today. I'm going to try with the cases that I speak about to speak just about the cases during the past year, but by necessity, I'm going to have to speak about some that you know, but that are so important that I can't go without most mentioning them. To me, and I think most of you would agree, certainly the most important case in the last 2 years, and probably in the last 8 or 9 years, going back to Blake And Cahill is Runner versus New York Stock Exchange, which was decided in December of 2009. Don't look at it, but it's at pages 68 and 69 of the course book. And everybody here knows Runner, right? Everybody know the facts of Runner? No. Okay. This is very important. So I'm not going to go through the facts of a lot of cases, but this is important. And maybe we'll do a little demonstration. Because it goes to this whole concept of elevation-related risks. The labor law, section 240, was originally enacted, and if you go back all the way to 1912, when the cases under the old section, and then they'll go back to the Zimmer, which I'm going to talk about, which was decided in 1985, and some of you know, and I'll tell you a little bit about it. It really dealt with and was directed at, objectively speaking, to work at heights, way up on scaffolds, up on cranes, up on hoists, way above the ground, or being struck by objects that fell from a height. And things have changed. And certainly, they changed Judge Lippman getting on the court, and for a while with Judge Piggott, well, I'll talk about their little struggle that's going on between them in a minute. Okay, so Runner comes down. And in Runner, what happened is this. You had a plaintiff and co-workers, and they had to move a large reel of wire, weighed 800 pounds. What do they got to do with it? They have to move it. Think of this. You can all hear me because I have a real big mouth. They have to move it down a set of stairs, okay? So Howard, you have to be the 800-pound wire. Come over here. Stand right here.
This is unrehearsed.
I don't have enough people, so I may have to get some people up. I really want you to understand what's going on here. So Howard's a wire. Make believe there's stairs behind him. You're not going to push them off, don't worry. Okay, so here's what they got to do. They got to get the 800-pound reel of wire down about 4 steps, right? So what do? Instead of using a come-along or a winch to see, 800 pounds is a lot. Maybe for not some of you, but I certainly couldn't hold it. So what do? They take a rope and they tie it to the wire. And what they do is, I'm not going to get you up there, but think of Howard standing, the wheel is in a door, the wheel is here, okay? So here's what they do. They tie the rope to him. Sorry, you're going to be the one to push him on this thing.
Okay.
They tie a rope to him, and there's a door frame. Think of me as a door frame, okay? And they put there's a metal brace, okay, between the door frame. And they take the rope and tie it around him, and then they wrap it around so you have like a counterweight, like you see on mobile boom cranes. All the blocks on the back, those are counterweights when you see them on the cranes around the city. So the crane won't tip over. So this is like a come-along, but it's a human come-along. They have a plaintiff and 2 of his co-workers are holding this, thinking that as they then start pushing the reel down the stairs, they're going to be able to slow its descent, okay? Like a Three Stooges movie, really. All right, so what happens is they start pushing Howard down the stairs, the 800-pound reel of wire. I wished I had more people here because we really were going to throw him off the stage, but no, I would never do that. But, so what happens is this. They start pushing him down. Here's these guys, okay? They're holding it. You can imagine what happens. This is 800 pounds. I don't know how much these guys weigh, but the reel starts going down, and the plaintiff is pulled, and his hands are jammed into the bar. You can sit down. I just wanted to give you, and he's severely injured. Now, you might ask yourself, how is that a 240 case? Is that really the type of elevation-related risk that 240 was designed to guard against? The case was tried in federal court, verdict for the defendant, thrown out, and a directed verdict for the plaintiff went up to the Second Circuit, and it was certified to the Court of Appeals. Despite the fact, as we know, that the reel didn't strike the plaintiff, and plaintiff moved horizontally. That's why I had Howard stand here. Here, the reel is the thing that fell. That's where the elevation was. Plaintiff never fell. The plaintiff was pulled by this great weight that fell into the bar. So despite the fact that he moved in a horizontal direction, and it was the reel that fell down, the Court of Appeals per Judge Lippman held the trial court was correct in tossing the verdict and in directing the verdict to the plaintiffs. And I'm going to read this. I'm not going to read much to you, but Runner, as far as I'm concerned, and you can tell me later if you disagree with me, but as far as I'm concerned, Runner has been misinterpreted both by the courts and by commentators. Here's why. And this is the most crucial statement in the case, and it's what you should always remember about Runner. They said, Judge Lippman said, starting out, the single decisive question is whether plaintiff's injuries were the direct consequence of a failure to provide adequate protection against a risk arising from an elevated related differential. Now, why do I say that's such a crucial statement? Because of further statements in Runner, which I'm going to put into context for you, a lot of courts and some commentators have focused on Runner and cited Runner for the proposition that this primary issue to be considered is whether the force of gravity was involved as being the only test for 240 liability because of this statement in Runner, which followed the single decisive question. The relevant inquiry is whether the harm flows directly from the application of the force of gravity to the object. Well, that's true. But it's only true after you decide whether there's an elevation-related differential that's significant enough, and you may then, because here they went to the force of gravity because the plaintiff didn't fall off anything, he was pulled because the reel fell. If you were going to buy this interpretation that the only focus was the force of gravity, then any time, and we've all seen these cases tossed right and left, a crane swung and hit someone at ground level with its log. It's not an elevation-related differential. Certainly the force of gravity is involved, but it's not a 240 case. First of all, when Lippman in Runner cited that language, he was basing it on language from a very well-known case, which I'm sure most of you know, and it's Ross versus Curtis Palmer, which was decided by the Court of Appeals in 1993. I don't have to give you a cite because it's in the quotes from Runner, which I just gave you the pages where that's on. But in Ross versus Curtis Palmer, as some of you may remember, it goes back, and I see some of you have been in the last few years. Here's what happened. This guy's on a scaffold, a worker, and because of the way the scaffold was positioned, he's got to bend over. Now, he's at an elevation related. He's way up in the air. the scaffold, but he had to bend over to do his back, do his work, and he injured his back. And the question was, well, why isn't that a 240 case? He's up on a scaffold working in an elevation, but the elevation-related risk may have been there, but it certainly wasn't a competent producing approximate cause of his accident because there was no gravity-related force on his body which caused his injury. He didn't fall off the scaffold, he just had to bend down. In that case, that's within the context with which Lippman used that language. And he also brought out the language from Rokovich versus Consolidated Edison, which was back in 1991. But that was a case with a hot oil and a 12-inch trench, and the guy steps on it, and it's way up on a building under construction, but there's no force of gravity involved. So that's where that language comes from. So that's how you have to put it in context. Because you read a lot of these appellate division cases, and they're talking about the force of gravity. And if you really look at them, I give them the benefit of the doubt. They're doing it because there's no elevation-related differential. So here's what I want to say. You still need an elevated-rated differential, although not as much, I don't think, as you did before. And you still, as I'm going to discuss with you in a minute, need to show the failure to provide adequate 240 enumerated devices. Further in Runner, the court finished up by saying the injury must result from the failure to provide statutory protection, one of the enumerated or other devices in 240, against the risk from an elevated-related differential. Now, there's two very important cases which aren't in the course book because they came out after the deadline. By the way, before I get into them, the reason I wanted to discuss Runner with you in a little bit of detail is, listen to this. 2 years ago it's decided. It's been cited 3 times by the Court of Appeals, 28 times by the APDIV, and 57 times at the Supreme Court level. So it's an important case, and we all should understand it. There's 2 must-read cases that have come down within the last 1 to 6 weeks from the Court of Appeals. The first one is Wilinski, W-I-L-I-N-S-K-I, v. 344 East 92nd Housing Development. It's Court of Appeals, decided October 25th of this year. The only site I have on it, of course, is a slip-up. 2011 NY slip-up 7477. Has anyone here read Wilinski yet? Okay, one person. Okay, that's fine. Look at it. Next case I'm going to tell you, Joanne Bell's back there somewhere, she's speaking, and she's a great defense lawyer and a great friend. We got very close on this product liability case, which she was an adversary, but not really, thank God for me. She sort of had a mutual interest. I did very well in the case. I think I would have lost if she had it. But the second case, she got to me on the day it was decided. I get mine on Friday because I have all these alerts. She's usually ahead of me, so this time she's leaving by 5 days. But she sent it to me, which was very nice. Okay, so Wilinski. The majority opinion in Wilinski was by Judge Saparik. But I want you to understand, and as defendants, you should be very careful about what cases you're going to take up to the Court of Appeals, because the chances are more likely than not that you're going to make bad law for yourselves. Not always, but you should be very careful about what you want to take up. understand what's going on in the Court of Appeals, and it's obvious based on Wilinski and the next case I'm going to discuss, which just came down on November 21st, called Salazar, that there's a philosophical battle going on as to the interpretation of 240. And surprisingly to me, because I know both these judges, on one hand, the more conservative interpretation, based upon the recent case law, is really led by Judge Gene Piggott, who's a great judge, who happened to be a plaintiff's trial lawyer years ago, and he's leading a faction consisting of himself, and these aren't surprising, Judge Graffeo and Susan Reed, okay? And which they interpret 240 more restrictively. And then you have a faction, which is the opinion in Wilinski was written by Justice Parrott, but, you know, Lippman gets a kick who writes for the majority, so. The other faction is really led by Judge Lippman. If you've read enough of his opinions, you can tell that. And he's joined by Judge Parrott and Jones, and who interpret 240 more liberally, really going back to Zimmer versus Chemung County Performing Arts Center, which the basic statement was that 240 should be interpreted as liberally as possible to achieve the purposes for which it was enacted. And that's going way back to 1985. Okay. And then you have Judge Smith as a swing vote. Now, and he was with the majority of this 3-2 decision in Wilinski. And here's what happened in Wilinski. And this is why it gets very frustrating for all of us as plaintiffs and defendants lawyers, because we never really are sure sometimes, do we have a case or not. If you follow law enough, you have a pretty good idea. From a plaintiff's view, as Chris Sally likes to say, the plaintiff has to tell a 240 story. That's not means that he's going to make something up, but the facts have to fit into the parameters of the law. From a defendant's viewpoint, you're going to have to see if you can knock someone out on the sole proximate cause, recalcitrant worker defense, which have really been merged. Most defendants, you're moving on sole proximate cause, whether it's a recalcitrant worker defense or not, and the courts are writing them up as sole proximate cause defenses. Okay, so what happened in Wilinski? Are you familiar all with the so-called same level rule? Okay. All right, we have someone. You want to come up here and take my place? All right, the same level rule. In Wilinski, the court rejected the so-called same level rule. Or, at least, according to the majority opinion, the appellate division's misinterpretation of the case in which the same level rule was enunciated, and that was Miseriti versus Mark IV Construction. And the site for that, if you want to go look at it, is 86 NY 2nd 487, and that was decided in 1985. And this gives you a good example of this pendulum effect, because I'm going to tell you something right now. What happened in Miseriti, very briefly, is a concrete wall had been built, it had been finished, and it fell over on a worker, and he eventually died from his injuries. And the court basically held that where a worker sustains an injury caused by a falling object whose base stands at the same level as the worker, no matter how high it is, if the base and the worker, if we're next to each other, the base, he may Howard's a lot taller than me, not that much, and he falls over on me, we're still at the same level because our feet are in the grass. no 240. That was the rule, and the so-called same level rule in Missouri. And so they go through a lot into Pelican. Here's what they do. The majority of Wilinski states this, and you've got to read this case. It's crucial. The court states, we reject that interpretation, that what I just told you, the same level rule. We reject that interpretation and hold that such a circumstance, plaintiff and the object that falls on them, being at the same level, does not categorically bar the worker from recovery under 240. And they held here, in this case, there was a question of fact as to whether the injury resulted from the lack of a 240 prescribed safety device. And as you know, 240 has enumerated devices and then at the end other devices. But there was no proof real solid enough either way, whether they had a device they could have used or they didn't. My question when I read this case is, how did they get around Missouri? And they go through the fact that in Missouri this concrete firewall had already been constructed. There was no safety device that could have been used or should have been used to brace it or secure it, and it just collapsed. And it was a normal risk on a construction site. But that's not what the case said. That's not what Missouri said. It's a pendulum. It's no different than way back when I was in law school when the Supreme Court was changing in the criminal procedure area, and we asked Escobedo and Memorandum and all these cases. Before that, you could beat the crap out of the suspect. It was fine. You didn't have to give him his rights. And now it's changed again. You know, Miranda's been really eroded, and Escobedo's been eroded. So it swings back and forth depending upon particular persuasions of the judge. We hope that to some extent, and our Court of Appeals does really, unlike our present Supreme Court, try to stick with precedent, and they fit in a more of a logical way when they want to change it, unlike what's going on our Supreme Court level. And I'm happen to be a pragmatist, politically. I'm not criticizing them. I'm just saying it's sort of disingenuous in the way they write these opinions. If you follow the Supreme Court, I happen to like to read their opinions. Okay, so they held us a question of fact because they weren't sure whether they got a safety devices. And I just asked you, how do you get around Missouri? Here's the facts. The plaintiff and his co-workers were on a demolition job, and they're demolishing walls. And prior to demolishing the walls, they had demolished the ceiling and the floor above. They had left standing 2 10-foot-high vertical pipes, so coming out of the ground, okay? And now, so they're demolishing the wall, and debris from the wall falls on these 10-foot-high pipes, okay? Stand up again. I need you, you're my demonstrative evidence. Because he's told it. Stand on the chair, not my good. So how is it, what are the pipes? So what happens, debris falls on Howard, and I'm 5'6". I'm the injured worker. And falls on, and both of them, but you can see we're at the same level. Why is it the same level rule? Our feet are both on the ground. That's what Missouri held. Okay, sit down. You know, he happens to be an adjunct professor at Brooklyn Law School, so I shouldn't talk to him that way. But he's my really good friend. Anyway, so he's 5'6". So what does that mean? That means the pipes fell 4 feet, right? But they're still at the same level, and the first department forced the case to dismiss the claim based on the same level rules enunciated in Missouri. And those cases, as most of you know, these same level cases had been tossed for years since Missouri was decided in '95. in any event, the court distinguishes Miseretti on the basis that the construction of the wall that collapsed in that case, causing plaintiff's fatal injuries, was completed, and it didn't collapse as the result of a failure to provide a 240 protective device. Hence, in Wilinski, the court interpreted the holding as Miseretti as based on the lack of a causal connection between the worker's injury and failure to provide an enumerated 241 safety device. And held it was a question of fact as to whether there could be such a device, and sent it back for trial. And that was just decided. So then, 10 minutes. But you cut off my time. Just kidding. I'll move it along. These are the cases. These are very important. In any event, and also they apply the single decisive question, elevation-related differential test from Runner, and they said that since this pipe was 10 feet high, even if it's at the same level as the plaintiff, it fell 4 feet, that's enough. And it was because of the force of gravity, and the harm was caused by the force of gravity, but there wasn't enough proof on that. Piggott dissented, joined by, and Piggott's changed a little bit. He used to be a lot more liberal in his interpretations, but I respect it. He was joined by Garfeo and Reed, and basically they stated that Miseretti was controlling, not unreasonable, and no elevation-related differential. And technically, if you think about it, there wasn't, because it's the same level, but the pipe was higher and it fell. So he says, since the base of the pipe at same level as plaintiff, no different than the wall in Miseretti. Now, the next Court of Appeals case, which came down a couple of weeks ago, and also was a must-read, it was decided on November 21st of 2011, is Salazar versus Novalex Contracting Corp. 2011, New York slip-up, NY slip-up, 8446. Here, you have Judge Piggott writing for the majority, joined by Garfeo and Reed, of course, and this time Smith comes over with him, sort of like Kennedy in the Supreme Court. It's a swing vote. Lippman wrote the dissent, and you can see if this is a very interesting decision because Lippman and Piggott are really sort of needling each other in a nice way. And he was joined by, obviously, Saparic and Jones. The facts were this, I got to give them to you quickly. Plaintiff and other workers were laying concrete floor in a basement, and there's trenches for pipes. You know how they put these in. I'm sure a lot of you have been to construction sites, and if you haven't and you do this work, go to construction sites. Secondly, in that vein, well, you got to know what these safety devices are. And if you can't go on construction sites, simply Google them and look at images, and you'll see them. Thirdly, look at YouTube and look at the manufacturer's websites. They all have videos up. If you want to do this work and understand it, you don't have to depend on paying an expert $1,000 to explain these devices. You can learn them for yourself because we have the internet now, which is such a great resource, and it's something you can do. I used to have all these books with pictures of every safety device. I don't even need them anymore. I think Chris threw them out when I wasn't around. Anyway, so they're laying concrete, and these trenches have pipes, and they have to be covered with concrete. They're not going to leave them open. And the worker's using a concrete rake to pull the concrete, and he's moving backwards. And he
steps into the trench, falls, and he's apparently injured, at least according to the majority, as he's getting out, but let's assume he's injured when he goes in. And that's what his job was. The trench was about 2 feet wide, 3 to 4 feet deep, and his claim was, the plaintiff's that is, was the trench should have been covered or barricaded to prevent him from falling. And Judge Piggott, with a little dig at his friend, and they are friends, Judge Lippman, cites Wilinski, which Carrick wrote, but I'm telling you, Lippman was behind, for the proposition that the barricade or cover the trench would have been contrary to the objective of the very work being done, which was to fill the trench with concrete. So how are you going to barricade it or put a cover over it when you got to fill it? And the case was, the 240 case was dismissed. And there's also, in both these cases, discussions of 241.6, which you could read. And I know Joanne disagrees with Wilinski, right, Jim? Wilinski, the 241.6. I think you do. And Lippman, in dissent, said, wait a minute. Piggott's misinterpreting our holding in Wilinski because A, there was an elevation-related risk, this 4-feet trench, the force of gravity acted on the body of the plaintiff, and he goes all the way back to Zimmer, as I say, versus Tremont County Performing Arts Center in 1985, and that's the pendulum. That's where the court's going, by and large, to that very liberal interpretation of 240. Now, I don't really disagree that much with the decision in Salazar, but I think by and large you're going to see these cases going the other way. Now, I only have, what, 5 minutes? All right. Do you remember Gasquez versus State of New York? The Court of Appeals case that came down in, it's at 78 and 112 of the book. Memorandum decision. It's the kind of cases that drive me nuts. Plaintiff's painting the Kosciuszko Bridge. He's on a motorized scaffold. It's going up. His hand was crushed as the motor moved the scaffold up, and it's trapped between an external motor and part of the bridge. One sentence. This is what drives me nuts for some of these decisions, because none of us know what they're talking about. Maybe you guys do, but I don't. In one sentence, this injury was not the direct consequence of the application of the force of gravity to an object of a person. Well, what are they talking about? Why not? Well, you could argue as a defendant, and I had it happen to me, a re-argument on the hoist case with a motor. No gravity because the hoist's motorized. Forget about that now, okay? It's never going to win because of other cases. No gravity because the hoist is going up. No 240 because no elevation-related differential. This case, if you really think about it, although they didn't say it, but they did cite Runner in the case, was really because there was no elevated differential. But I was intrigued by it, and I called up the lawyer for the plaintiff who argued the appeal, Jay Breakstone. He said, Tony, you gotta watch your argument. And you know you can go to the Court of Appeals website and go into their archives. So when this case came down, I watched it about 10 times. And you wouldn't believe it. Over again, Lippman and Susan Reed were asking, especially more the defense counsel, and sometimes Jay, questions is not about elevation, or the question, how can you have it being gravity related when it's going up? Well, don't start asking judges or lawyers about scientific principles and Isaac Newton's theory of gravity. So I turn to my engineer, Chris Sally, my partner, who has an engineering degree and helps me with these technical things. And the fact is, of course you can have gravity when you're going up. When you take an elevator, when an elevator is going up, what's the motor doing? It's fighting the force of gravity to go up. Just like when it's coming down, the motor's mitigating the effect of gravity so you don't have a free fall. But I think it was a correct decision because there was no elevated related differential. All right, I got to skip over. Take a look at, I'm going to just go really quickly now. Look at Strangio versus Stevenson Environmental Services. The fourth department decision, which really sets forth all the facts, is at page 76 of the course book, and the appellate division that modified and said there was a question of fact, the fourth department had tossed the case, is at 112. Okay, very quickly. So, give me 3 minutes. Okay, I want to do it. Sole proximate cause recalcitrant worker defenses. As I said before, they've been merged into the sole proximate cause. Whether he didn't use something that was available or wasn't available or whatever, they're all being, every motion I get against me is on the sole proximate cause theory, whether it was failure to use a device or follow an order or whatever. So they've been merged. All right. Prior to Cahill versus Tri-Board Bridge and Tunnel Authority, the leading recalcitrant worker cases are set forth at pages 6 through 10 in the course book. Smith versus Hooker Chemical, Gordon versus Eastern Railway, Higgins versus State, Soap versus General Foods, and Jastrabisky versus North Shore School District. They're all Court of Appeals cases except for Smith, which was fourth department, leave denied. Here's what the rule was then. As of the last case, Jastrabisky, 1996, and it's the rule again. Even after Cahill, they've gone back again. Here was the rule. You had to have, for a recalcitrant worker, so you had to have a refusal by plaintiff to follow a direct, immediate order not to use the device. Remember Cahill? He was told to tie off his scaffold as he was going up the Tri-Road Bridge weeks before, and they tossed his case. So you had to have a refusal by plaintiff to follow a direct, immediate order not to use the device. The action had to be contemporaneous in time with plaintiff's refusal, and safe and appropriate devices had to have been available. Then you had Cahill versus TBTA, it's at page 10. I know you all know that one. And they said it could be weeks before. That's not the law anymore. Then you had Montgomery versus FedEx, the Court of Appeals 2005, which was a total, absolute aberration. Because the court found the worker to be the sole proximate cause of his injuries. Remember, he used a bucket to get up into the motor room of an elevator motor room, and he had to jump down. He was injured when he jumped. The appellate division, in a 6 paragraph decision, didn't make any reference to the availability of ladders. They only stated it should have been his normal and logical response to go get a ladder. Where did that come from? I don't know. And I don't think they know either. And the Court of, and here's, Montgomery's still being cited. Here's why. The Court of Appeals affirms, since, according to them, ladders were readily available and plaintiffs should have gotten one. There's absolutely, I've seen the record, there's absolutely nothing in the record, there's nothing in the first department decision stating anything about ladders being available. So when you see Montgomery cited today, it's being cited for that statement in the Court of Appeals decision that the plaintiff fails to get ladders which were readily available, which no one knew if they were because there's nothing said about it. But that, as you see Montgomery cited, take it in that context. Blake, we all know about it, it's at page 21. Plaintiff set the ladder up himself, didn't know if locked extension clips, and it was a defendant's verdict, which was affirmed. They never said anything about Haynes, which was way, way back, 1978, where the exact same case, and Jack Fuchsberg had decided it, and it was for the summary judgment for the plaintiff. But here's what you have to take out of play, and I don't have time to even read you the quote I wanted to read you, but this is the thing in play. Once a plaintiff establishes a failure it's a given that it's a height related, okay? But once, for my following statement, once a plaintiff establishes the failure of the defendant to provide a 240 enumerated safety device or other device that's covered by the statute, or a defective one, he can't lose. Because any conduct on his part then would be culpable conduct. So you have to have a misuse now of it to get out on the sole proximate cause. The plaintiff's either going to win on summary judgment, or if the defendant's, and a lot of you are very good at doing these depositions, get enough out of them, you'll have a question of fact. All right, I'm done, right? Okay, just let me finish one thing up. I have to give you. Look at Gallagher versus New York Post. I know it was decided in February of 2010. This is page 42. But here, let me just give one quick thing. I have about 20 more pages. All of the 2011 cases following Gallagher, the cases decided in the last year, are at pages 50 to 64 of the course book. You can read them for yourself. Here's what I think. I think we're, as to the state of the law regarding 240, I'm done in a minute. We're pretty much back to pre-2004, pre-Cahill, as far as the recalcitrant work. Back to that old law rules that I just gave you. Blake is still good law. Montgomery is not. At least the facts underlying it aren't. So as I said, when you see it cited, it's only based on the Court of Appeals' unsupported statement. The ladders were available. They weren't, or we don't know if they were. But that's when you see Montgomery stated. But the law, certainly, if you can prove that there were no safety devices, ladders, scaffolds, whatever, in the immediate vicinity of the work, you're not going to knock a plaintiff out on a recalcitrant worker defense. That's not the law anymore. Cahill is still followed, as I said, if it's established that adequate safety devices were provided and the plaintiff chose not to use them or misuses them. And also at page 64, you're going to see a little thing I put in with Chris and Howard, which is the demise of security falling out of this places, question mark. And if that goes through, Ducci, which said you had to be in the process of hoisting or lifting. Then you had Altar, which said no, it maybe was something that had to be secured, didn't have to be in the process. And then you had Quartarucci, which really confirmed that. And then you had this case, Harris, which is all in the course book. And I hope I got through the concepts to you, current state of the law. The cases are really pretty well set forth. And I hope I woke everybody up. Thank you.